I have a couple extra copies of the rule books if you guys don't have them with you.
Thank you.
Thank you. You're welcome. I've probably got a few more downstairs. I can bring them next time. A lot of remedies. When we talk about remedies, historically, remedies meant equitable remedies. When I took this course in law school, that's what it was called, is equitable remedies. And what we were looking at is declaratory relief, injunctive relief, specific performance, things along those lines. Our approach in this class is not just going to look at equitable remedies, but it's going to look at traditional and more modern remedies as well. But really, any remedies course starts with a better understanding of Rule 65, which is the request for injunctive relief. And so I want you to look at that and think a little bit about it. Many of you know from having me before is that when we talk about injunctions, I want to know that you know the basics, that there are three different types of names we give to the life of an injunction: a temporary restraining order, which can be issued with or without notice; a preliminary injunction, which is issued after some form of hearing; and then a permanent injunction, which is issued only as a final order in the case on the merits of the case. And when we're talking about injunctive relief, that's relief granted without the benefit of a jury. This is a judge-made remedy only, no jury. And it's an important order because it can be issued without notice. But when it's issued, then it carries with it the sanction of contempt. If you look at Rule 65, what it talks about are those things that we just talked about, but it also talks about some of the more basic matters of how in practice you move for an injunction. You need to file an affidavit or a verified complaint if you look under 1A in order to obtain a temporary restraining order or preliminary injunction. And there will be times where that can be granted without a hearing, but you still will have to go before the court to make some form of presentation because it is a court order. If the court either denies your TRO or grants your TRO, at some point very soon it's going to expire. And then at that point we're looking at the preliminary injunction hearing. We're going to read cases where we talk about what that hearing has to look like, whether it is in fact an evidentiary hearing where witnesses are sworn and testimony is taken, or will it suffice that the court hears you by way of paper filing and the like. So that becomes important. We're going to look at those cases as well as we start to think about it. And obviously, if you look at Part 4 here, that parties against whom the injunction is granted have some rights to try and dissolve that injunction and be heard. And therefore, there is, even if not heard prior to the grant of the temporary restraining order, there is a process for you to be able to come into court and be heard post that grant, so that there is some opportunity to provide that due process that you have to be worried about. Security. The moving party, and again, we're going to look at this a little more carefully. The moving party has to provide some security, and that's what we usually call the bond, in the event that the injunction is later found to have been improvidently granted, to not be granted based on sufficient facts and law. And what that bond, that security does, then it gives the party against whom the injunction is granted, which is almost always the defendant, but it doesn't need to be, because a defendant could assert a counterclaim and seek injunctive relief. The party has to have a claim, right? Has to have a legal injury. And it's almost always the plaintiff who seeks injunctive relief. But a defendant who files a counterclaim that has a legal injury would also have the right then to seek some form of injunctive relief. You don't just get to go into court and motion for an injunction unless you have a complaint, unless you have a legal injury that you're alleging has happened, and in fact that you are able to satisfy what I call the five-part test. Lastly, as you look at the end of this, what you want that order to say, what you want to effectively do, has to be clear, because the party against whom that injunction is granted potentially can be found in contempt if of noncompliance with the order. Because of that, then you better be precise with respect to what it is you want in the order, because the court's going to ask you for the language of that injunction. You're the moving party. It's your obligation to show what it is you want. And then when the court rules on it, they have to provide some formal decision so that it can be seen that the injunction was properly considered first and then either granted or denied. And sometimes, as you can see, where it can be issued very early on in the case, as you start to think about going from law student to lawyer, you start to think about, well, are there ways to use injunctive relief that would assist me in essence, getting the client what they want, but getting the client what they want sooner rather than later. The fact is, once I can seize the high ground, there's a greater chance I can keep the high ground. And so there will be times where we seek injunctive relief early on in the case, and that victory early may be dispositive of what it is we ultimately want. I think the Clinton versus Nagy case that we're going to look at is a good example of that. The whole case is really resolved within the first 6 weeks of its filing. And so sometimes we look to use injunctive relief to head off sort of a long, protracted battle. And another thing to think about, and I've mentioned it at times to you, but I think you need to think about it a little more importantly now as we transition to lawyer, is that, remember, the person who files the complaint, they know what's coming, right? I mean, they have an opportunity to gather their evidence and to satisfy their Rule 11 obligations and to really think about how to lay out why they need the relief they need and to have all that support. By the time the adversary, the defendant, then sees the complaint and the memo and the affidavits, I've had ample time to be able to be an effective advocate and to put forward probably a pretty strong case. Defendant doesn't have nearly that time in responding. And so, there's an argument that in some ways the defendant can get blindsided by an early request for injunctive relief. And you need to think about that as you start to think about, is there a way in which I can correctly, legitimately, ethically seek injunctive relief, and at the same point potentially put the defendant, the adversary, then in an adverse position throughout the duration of the case. And we're going to see a few cases where that's what happens. Whether that was part of the calculus or not, I'm not sure. But it's not improper for it to be part of your calculus going forward, right? Is that if we're looking and thinking about injunctive relief, well, how can I use this to my tactical advantage as well, if it's within ethical and legal requirements? You guys got questions on Rule 65? What we didn't talk about is what I call the 5-part test. No adequate remedy at law, right? You must show that the moving party has no adequate remedy at law. What that historically has meant is that that money damages will not satisfy the plaintiff's loss. What the modern trend tends to be with that analysis is that money is not as complete and sufficient of a remedy as injunctive relief would be. No adequate remedy at law. 2, likelihood of success on the merits. How likely is it that the plaintiff will succeed in its case here? The greater the likelihood they're going to win at the end, the greater the reason they should get now what they're going to get in a couple years from now. Conversely, if you don't have a snowball's chance in hell of winning, you should have a snowball's chance in hell of getting this injunction, right? III is the 3rd, immediate irreparable injury. Immediate irreparable injury. Think about that, right? Before we ever have a trial, before we ever have really a dispositive analysis of the evidence and the testimony, you're asking, either by way of TRO or preliminary injunction, for what we will see when we read our cases is an extraordinary remedy. That's the way it's referred. Well, if that's the case, then you should have, if you're going to try and seek such an order, you better be able to show that you have an immediate and irreparable injury Because if it's not so immediate, if it's not so irreparable, again, you can wait. And that is oftentimes a significant part of the analysis. The fourth factor is the balance of harms. In situations like these where we're seeking injunctive relief, there are clearly competing harms. The party who wants the injunction is telling us they're suffering, in essence, from irreparable, immediate harm. While the fact is when the court looks at the analysis, there almost always is some competing harm if we're either forcing a party to do something or prohibiting them from doing something. The court must balance those harms to see how the harms lay out, to see, in fairness, who should succeed. The last part, the fifth part of our test, is what, if any, public policy considerations are at stake here. And that becomes a very important part of the analysis for many cases. Some cases you look at and say, well, there's nothing earth-shattering here. He wants his next-door neighbor to stop putting trash on his land, or leaving his lights on too late because it invades his child's bedroom, or he doesn't want to look at that, whatever it is you've got in your yard that is causing them problems, or the paint fumes are too much, or the odors from whatever it is need to be stopped. There's not always a straight public policy consideration, but think about injunctive relief when we talk about these church situations, protesting various servicemen's funerals or things along those lines. We've got free speech rights, we've got religious rights. We also have some significant issues, in my opinion, with respect to the ability to grieve in private. But the court has to balance all of those, and that last one in those situations is going to be a significant public policy issue either way we go with that. And so that can, in some cases, be the ultimate trump card. Maybe in Weinberger versus Romero-Barcelo, which we're going to talk about, that was one of the ultimate trump cards. But that's part of the test. Those five factors, no one, other than the first, no one is really more important than any other. The first one, though, if you cannot establish that you don't have, that you, in fact, money might make you whole, that this is really not a claim that needs an extraordinary remedy, then the other four parts of the test may not be as significant. But once you can establish that this isn't a claim where money damages is really going to make you whole, then there's none of the other four factors are dispositive. You put them in the mix, the judge tries to make the analysis of how those factors weigh out, and there's a significant amount of discretion as to whether the court feels the court grants or denies the injunctive relief. A lot of that will rest with the discretion of the court in granting or denying injunctive relief. We have Weinberger, which one of the things it stands for, I say, is that there is never an entitlement to injunctive relief. It's almost always rests with the sound discretion of the court, provided the court does the appropriate analysis. So we're going to look at a lot of injunctions, a lot of the process of injunctions, how it works and how it was done. But it's important to make sure that we're all on the same page with respect to both the rule, the standards, and how that process works. Anyone have questions on Rule 65? Cal.
Just with the five-part test, you stated the balance of harms. You said the immediate harm versus what other harm?
No, I said the harm to the plaintiff versus the harm to the defendant. The harm to the party who seeks the injunction. What harm are they suffering, as opposed to the harm that the party against whom the injunction is sought will suffer?
Thank you.
Right? If a bunch of old cases, some of you don't even know what a drive-in is. But there's a bunch of old cases with drive-ins where they said, the screen is invading I should be able to see it from my house in Dorchester. We could see the Neponset Drive-In. And back then they used to do a lot of raunchy movies, frankly. But neighbors would complain that I can hear the noise, I can see the images. I don't want that stuff there. If you've ever lived next to a used or new car lot, those lights tend to stay on all night. If you're in close proximity, you would argue that, let's take the car dealer situation, which is the easiest, I think. The moving party is saying, listen, I can't use my house the way it was designed. My kids can't sleep. Those lights are on 24/7, and they're bright. And maybe there's even a little buzz. You know how some of those lights have a little buzz to them? That disturbs my peace and peaceful enjoyment of my property. I'd like them to turn the lights off 2 a.m. to 6 a.m., whatever it is. Or I'd like to turn them off sooner, right? Well, what would the car dealer's argument be as to their harms, potentially? Go ahead.
They're going to have security issues. Obviously, they're going to suffer monetary losses, damages, and theft.
Right. Right. We got all these new cars here. People steal cars. People come in for equipment on cars. I've got, I don't know, you look at some of these lots, there must be $1 million worth of, these days, right? $1 million worth of vehicles and their parts on my property. And the fact is, you can tell me to turn the lights off, but now so I'm supposed to hire 2 people to walk the grounds with dogs all night? I mean, there is an alternative, and maybe that makes sense, but what we've got is our competing harms that have to be balanced. And that happens in a lot of these cases, and that's what you have to think about, is that obviously is a counter-argument, is, okay, you can issue the order, but recognize that we will have competing harms that flow from it. And that's what that means. Okay? Questions on any of that? Okay, so now I talked about tactical advantage. And then one of the first articles I have you read is "The Lawyer is Peacemaker," not the litigator. And then we'll do our cases too. I'm wondering if someone sent me a note already. I'm wondering what you think of that article. I mean, would all like to make peace, but unfortunately not. How do we get the other side to recognize that that's a cheaper, faster, probably more efficient alternative until I beat you about the head till you're bloody and bruised and then finally say, uncle? Or is that just my outdated notion of how I get you to the table? Go ahead, Guy.
I think the biggest risk here, if I was advising a corporate client, for example, which mediation is very popular in the business world, especially a lot of corporate people will like to pick up a phone and try to work things out, that kind of thing, before litigation. Biggest challenge with that is I would advise my client to be careful what you say.
Right.
Be careful how much you give up in that process, because the danger is if you ever get the litigation, all that stuff is usable.
That's right. Right. What else? No one else has any thoughts? You gonna be peacemakers or litigators? Or both? Huh?
I'm a litigator.
You like to fight?
That's it. Not in personal life, just at the end of the day, we got to eat too, and that's how you make your money. So.
See, I think, I appreciate articles like that. I would like to think that we're more interested in solutions, and we should be. And this is why I think it's important that you start to think about that to a much greater extent. But I'm not always sure, as much as I look for opportunities to try and resolve matters, but unfortunately, the litigation process oftentimes is how we get there. That you got to know you have something real to lose before you're willing to sit down and say, okay. And I think the other part of it for some is that they need to experience the process. As expensive as it is, as time-consuming and cumbersome as it is, over the years, I've had many people say, well, I want to hear what the judge says. Like the judge has some infinite wisdom, and some judges do, but an experienced lawyer oftentimes can tell you, well, these are the options, and this is likely the way it plays out. And that, these days, that could cost you 10, 20, 50 grand to get to that point. And I guess part of the thing I think you guys have to figure out, and as Kel says, you got to pay your bills at the end of the day. I settle every case within an hour's worth of work. I'm going broke, right? That's the other part of it. It's not in your interest, or to be overly cynical, your adversary's lawyer's interest to settle things quickly, right?
Sometimes you don't have a choice, though.
What, about settling quickly?
Yeah, sometimes don't courts make you do this type of stuff nowadays?
Listen, almost all cases, sooner or later, you're referred out to mediation these days. But you can always say no. But no, not no. You could say no, I'm not going to mediate. That was a mistake, because the court's going to want to know you tried. Okay? But when we get to mediation isn't binding. And at the end of the day, you're empowered to decide what it is you're going to do with your case. And there will be some mediators, some judges more so, will really put pressure on you to drive you to a certain result. But at the end of the day, you say no. So, I mean, you still are empowered to decide at the end of the day, are we in or out on this deal? But some judges, it's almost, to me, a more recent trend. You want to settle. If you don't. When I first came out, and that was decades ago now, there would be judges that they would get you for that, what they would call a final pretrial conference, where they're saying, "Now, what's wrong with you? Why are you going to try this case? He's given you a good offer." I mean, there would be a real banging of heads to try and get you to recognize that this is what you should do, and sort of deny your client their right to be heard. And there's a lot of clients that want to hear from the judge or the jury. They understand the process, and that's what they want. And frankly, when it comes at the very end of a couple of years of litigation and a couple of years of expense, it is hard to tell them, no, you don't get what you paid for all along. You ought to just listen to what they say will happen, because, well, we could have done that 2 years ago with a lot less money and time spent in. So that's why that becomes part of the problem, is that we need to think about it early on, but we need to get them there. And frankly, I pulled up a different article as I was coming up, and I was wondering about this thought, but it's not the same article. It's another article entitled "The Lawyer is Peacemaker," and what it's from the lawyer's perspective, it says, "Whew, this is a much better way to live. This is what I do now. I'm not a litigator anymore. I don't cause problems. I'm the mediator. I'm the neutral. I tell people that I'm not going to get involved in any of that. But if you come to me, we're looking at collaborative law, another, sort of, let's all get together, put our arms around each other, and sing Kumbaya, and figure out a solution to this." And he said, "And I actually like going to work now." Have you thought about that part of the process? Is that oftentimes your interaction with your adversaries isn't pleasant. I mean, if she says she wants to do litigation, there are times where I've worked with lawyers that I wouldn't throw a cup of water on them if they exploded in flames as I was talking to them. And others where you have a good relationship and it's a good experience, but unfortunately, honestly, the numbers are much smaller where we can keep it on a high road, even though the stakes are high. The higher the stakes, sometimes the worse your adversary may act, and that can be that can be aggravating and depressing at times, and you're always on guard, so there's some level of tension to it. I mean, you like that?
I think,
go ahead.
Like the article says, most lawyers will prefer to leave that touchy-feely stuff to the social workers and the therapists. And I don't know.
Because we're the warriors.
That's right.
No. That is sort of the thing, right? Okay, we'll have the counselors, but when you want the heavy hand, just call us.
I guess you can call me a counselor then, because I've witnessed some of the settlements in my office, and there's a tactical advantage even in that, especially if you do it in your own office. I like the fact that you can litigate, Cal, because you know that, okay, if this doesn't work, then I'm going to take them for all they got. But at least I can say, at least I tried. But what they do in our office is they put them in the smaller, uncomfortable room, and they bring up the heat, and they make them really uncomfortable. And then they're there all day. And to be honest, we just settled the case, $900,000, and I think had it gone to trial, they probably wouldn't have gotten that much. Mm-hmm. Because if you can make it seem and you can be persuasive, I like the mediation part.
Yep.
But I like also knowing that I can take the next step and take them for all they got if they piss me off.
Well, and the other thing, part of it too, is just so as you add in exactly what she said, is we tend to think, by the way, that if we try it, we're going to be much better off. And if you assess your case correctly, the answer is probably not. Right? Juries tend to, A, they're unpredictable. B, they tend to be far more restrictive with money than you hear about these few outrageous cases. And B, as you have experience and you know your case, the strength and weaknesses of your own case, as well as your adversaries, you can pretty much assess what a reasonable range is here, and hopefully avoid some of the risk of the adjudicated result, where it's one way or the other. And that's something, obviously, to think about as well. the idea is service to your client, so what's best from that standpoint? You ought to understand that the whole notion of mediation, arbitration, conciliation, businesses favor it, clients favor it. It's speed, it's predictability, it's the end of the process. But each has its own strengths and weaknesses with respect to what it provides. But I think that you all ought to think more often about, being what we call pilgrims, early settlers of pilgrims, and there's some loss obviously to it, but in the long run, I think if you do it right, and not settle, we're not saying settle your client short. What we're saying is recognize that in every case there's many opportunities to sit down and talk and try and resolve the case, and you should always be welcome to those opportunities, because sooner or later someone's running out of money, and it may be your client as opposed to the other person. And the process is very expensive these days. And so let's think about what it is they want and how we can creatively get there. And if I've got to use my rules of civil procedure and get you to a certain point that way, I think it's vital that you know how to do that. But I also think it's important to listen to the signals and signs that the other side sends and says, to try and hope that we can be peacemakers more than litigators. With that said, from practical experience, I am always willing to talk. What I've found from experience is the defendants aren't always, and I'm sure they've said the same thing about my side, but the fact is that too often it's too late in the process where I've had litigations where not only could they have settled for far less than what they settled for a month prior to trial, but the fact is that they're now going to pay a premium for having dragged it out so far, because now now some of the things that might have tipped in their favor are now off the table. They've lost various rulings. So whatever, some of the small pockets of leverage, the doubt that I would have had, are now removed. The number is higher, right? I mean, and again, the number goes higher depending on whether I think you can do what you say you do, that you can defend this case. And if you've lost various, rulings on summary judgment, or questions going to be submitted to the jury, or the jury instructions, well, that changes the outcome of this. That changes the analysis, and so that you might have been better off early on before I got all this discovery and I knew that we could prove everything that we've said and more now, then dragged it out. I've got all the evidence. I'm now all ready. I've done all my work. But what the hell? That's the part you like. Well, if you like doing that, that's the part you like. Now it's the easy part. The work was slogging through, staying up till 3 a.m., putting all this together, and night after night. Now, let's just let it play out. So, and I see that a lot too, is that they don't want to think early on about what is it that will take it before we put 2 years worth of work in. And that's partly the system probably as well. Yep.
Could also some of it depend on whether it's repeat business, like in a corporate scenario, it's typically, I might want to give advice to my client to litigate sometimes, not litigate sometimes, and the better advice earlier I give my client, the more likely that client's going to keep.
Yeah, I agree. I think your best route to retaining clients, creating new clients, is to do an incredibly good job. And what that means, in my opinion, is give them the straight advice. Sometimes they are going to disregard it, but at least you've been straight with them about what your assessment is as to what they should be doing. And frankly, I've had cases referred not just from clients who have been happy and felt that I treated them truthfully and respectfully, but from people with beat. Because they recognize that if you do a good job, you work hard, you represent the interest of your client, the next time out maybe they want you instead of whoever they had. But I do think, and I've seen too many experiences like this with people I've worked with on occasion, is that they will promise the moon at the outset. They set ridiculously high expectations. They bring in the money then because they've promised stuff, and then they cannot deliver and weren't ever likely to deliver, and now the client has spent a fortune, is crazy angry, and that's likely to result in either them firing you, them settling for an unsatisfactory amount, or reporting you to the BBO, or all of those things. And oftentimes it's C. Because now, even if it was a fair deal, they don't feel like it was because they've been oversold at the outset. And so I think honesty with your clients, and obviously that representing each client as fully and as confidently as you can, and being ethical with them, and not maintaining expectations, but reining in expectations. Because it's easy to say, oh, this is a 7-figure case. There's not a lot of 7-figure cases. And if you tell them it's 7 figures and now you're coming back and saying, well, 200 is about the best we're going to do, ooh, you know, A, you shouldn't have set the number at the beginning that early until you saw a lot more stuff. B, even 200's not short money, but now you've made it sound like it's not enough. And that's hard. I think, again, as you start to transition, that client expectation, the managing of client expectations, it can be difficult, but it's a vitally needed resource, because that's what keeps this dialogue available, so that when the right opportunity comes, we can talk, and your client's sufficiently educated that they understand that this is reasonable, that this is a good deal at this point to be able to resolve it without the risk. But all of that goes into what you guys do. Let's talk about Weinberger versus Romero-Barcelo, because this is one of my favorite cases. You used to read it during orientation. I don't know whether you guys did. They don't read it anymore, I don't think. But I think this is a really important case, really simply from the standpoint of, if you look at the case, first of all, there's a bunch of things going on just to set the table. We're in federal court on a variety of federal questions. It is Puerto Rico suing the U.S. government. I think there's really no doubt that they can establish violations of law. And the only question really is, should they get that injunctive relief that they seek? And at the end of the day, the answer is they're not going to get it. Right? As you go through your analysis, at the end of the day, they don't get it. And so my question when I always look at this is it because they're suing the federal government? Is it because we don't care about what they want? Is it because we need a strong and vibrant national defense, and doing what we do, even if it's against Puerto Rico's wishes, that's okay then? That's the trump card here? Or can the Commonwealth of Puerto Rico legitimately say, well, where's the justice here? And so that's where I want to start. Did they get justice? Is this a just result? Because it seems like they have a violation of law. No? I mean, I think even the court calls it a technical violation, which I guess if that was you pouring pollutants into your stream that's adjacent to your house, I'm not so sure you would get the same deference on a technical violation. But
I agree with the dissent in this.
I like the dissent. So why do you agree with the dissent? I do happen to like the dissent in this case.
Well, Stevens makes a really good point when he says the Navy, like anyone else, has to adhere to the law. And I feel like if I was in that situation, dumping ordinances or pollution into the waters of Puerto Rico, then I think I would be tried differently than the result of this case.
Well, I think realistically you've got to think about that, right? It's nice if the government's on your side, that's great. That's the 800-pound gorilla is with you. Trying to beat the government is probably a slightly different issue.
I might agree with the dissent if there was obvious pollution in the munitions being discharged, but they said the area actually seemed to be improved. So in that way, I go along with the decision, and I think it just comes down to Supreme Court upholding the discretion of the lower court. I think that's the big key with this.
So it is consistent with the law, because if we're talking about discretion, there are hundreds of years of equitable discretion that's at work here. It is within the law, because where's the harm? But didn't Congress already figure out that this would be harmful? And Congress set out relatively detailed scheme here that this would cause harm. And it would seem to me that there must be some harm. I mean, you know the example I use. I can't use my little lead sinkers when I fish anymore because, God forbid, a loon should ingest one of them. But we can drop bombs and all these other chemicals from planes, and somehow that's a good thing for Puerto Rico. Wouldn't be so good if it was off Hyannis. TD? Go ahead.
Another I didn't understand why they didn't get justice is because from a common sense standpoint, why wouldn't that be harmful? It wasn't that why the act was put into place. So I just didn't understand why.
Doesn't the act sort of presuppose that this is harmful activity? And that was the scheme that's set in place, as these were pollutants. What was the first point? Yeah, your first point?
From the thinking about it common sense, why wouldn't farming water be harmful?
Well, what about that? Well, right? It does seem common sense. If we're putting all this stuff in the water, that can't be good. And Congress didn't think it would be good. But was that Puerto Rico's mistake then? Where's your proof, right? Okay, if it happened, we all agree it happened, okay? Prove that it caused any appreciable harm. So is it their failure? Or, if the court's going to deny injunctive relief, doesn't the judge have to say, "Oh, there's no problem here"? Because how do you say, "Oh my God, you wouldn't believe the problem we're creating down here"? But you know what? I'm going to do nothing, because that would be far worse. Hold on, let me get Gary, then I'll come over.
Ultimately, they made them come into compliance by getting the proper permit, and.
Whoa. Did they make them, or they just said, "Get a permit when you get around to it"?
Yeah, it was more like get a permit when you get around to it.
So that's made them come into compliance.
But I mean,
Only a lawyer. Go ahead, I'm sorry.
That wasn't the only relief, so they went a little bit more conservative and just said, all right, we'll start the permit process. And, I think it was, again, balancing of the harms where they brought up the issues of, national security, if they couldn't train in this area. And I think that was pivotal in the judge's decision as well.
Good, Gary.
But it's also the timing of that. In other words, the way the statute's written and should be written, and then thus at the court's discretion to say how much time does the statute say the injunction starts now, or do you have time to go get the permit? So the statute gives discretion to the court to determine, saying you don't have to enjoin now. You can give them an opportunity that might be open-ended or not to go get a permit. So that's part of the statute. The other point I want to make is that it's very difficult, if not impossible, for any Congress to write any statute that covers everything. So it has to be some court discretion. And in this case, going back to the original point, is it really a pollutant? The court should have some discretion to decide, is it really a pollutant?
Whoa, okay, hold on that. Don't they specifically lay out munitions as pollutants? Because you said, well, it's hard to describe every situation. The statute almost clearly covers this specific situation, right? I mean, it says munitions are pollutants, right?
I saw that somewhere, I think, the last time I read it. I didn't see it this time, but anyways.
No, it's still there. Let me ask both of you, though. Did they even order them to go get the permit?
No, I don't think so.
No.
So they didn't even do that, though, no? Give them something. Shouldn't they have done something for them? Go ahead.
Well, I was just going to say that I think that Puerto Rico would have prevailed if they would have said something about tourism, that they lost a harm based on tourism. That was off the island of Vieques, and they do have a lot of tourism. But I saw that it was nowhere in here, and I think that that's why, there's no emergency, and it's really not harming the water, that's why we're not going to force them to do something. But I think if they had done it the angle of, okay, we're losing funds, and if they could have proved that, although it would have been harder to prove, I think they would have had more success.
Well, at the time, though, this island was virtually empty and very, very rural. So they may not have shown a loss of tourism dollars with respect to the activity. And would that be enough for you guys, though? Or should the harm be the type that would flow from what the statute would expect? Pollution, not not, oh, where people don't like to get close by there because it's noisy. I mean, would you say that that's not the harm that the statute would have required, even if it is tourism dollars?
The
Or
statute's written, yeah.
they didn't expect tourism dollars, they're looking for pollution. And if you can't show pollution, you're not within the statutory problems.
They would have had to use a whole different statute or a whole different argument or a whole different case.
Well, and they did. By the way, if you look at the notes in the case, it lists about 20 different statutes that they say they think are problematic here. The reason we focus on the FWPCA is because there's almost no argument that there is no statutory violation. Even the court that denies the injunction says it's a technical violation. I'm hearing it rests within the sound discretion of the court. There are hundreds of years of equitable discretion involved. The result, therefore, is lawful. It's nothing discriminatory or by racial animus or otherwise. It happens to be consistent with the law. But did they get justice then?
Who's they?
Puerto Rico.
Well, you have to say where's the harm then, right? To Puerto Rico. They'd have to show harm. Now, whether it's tourism or whether it's pollution or...
They have to show harm to get justice?
Because you have to say, yeah, what's justice then? What, is it hurting? It's some island way off in the middle of the ocean that nobody ever uses. Where's the harm?
So what is justice then? Go ahead.
I feel that the decision itself was political. Political from the standpoint that with Puerto Rico not being a state,
right,
they don't have representation. I think if the same situation that happened with, say, a Nantucket, Massachusetts would have has a little bit more leverage than Puerto Rico. I think if in fact they even said it was a tourist, as was said in here, it's a little island. But we wouldn't say Nantucket is a little island. It's a paradise. So I think for Puerto Rico, they got the short end of the stick because, one, Puerto Rico didn't want the Navy down there doing any sort of exercises.
Right.
And that's been for centuries. And they still can't get the Navy out of there. And it's because of political might that they don't have and other states do.
What about that? So it's easy to pick on the disenfranchised. We're not going to do this in Tucket. We're not going to do it off the coast of Galveston, Texas, and we're not going to do it in Florida. What the hell? Let's do it there. No worries. So that is part of it. So that if you don't have juice, you should expect to get the short end of the stick in the legal system. Because that clearly can't be justice.
I don't think you expect that. But it happens in life, not just in the court system, but it just happens in life. That's just how it goes sometimes. Sometimes bad things happen to good people.
Okay, but so now you're lawyer. So now you're lawyers, and that's your role now is to just accept it. Because
no, you never roll over and just die. But at the end of the day, I mean, you make a very valid point in that you have money versus what? When you have more money behind you, you kind of feel like that bully. You can do that.
So your job as lawyers is to effect justice or just to enforce the law?
Justice for your client.
Oh, okay, Patrick. What does that mean then, though? Justice for your client. Does that mean winning?
That means winning.
So your job as a lawyer is justice for your client, which means winning, even if that client is the pedophile who did precisely what he's alleged to have done.
That's unfortunate.
No, that's unfortunate, but that's justice. Is that you all agree to that? That's your role? Because that's a dissent, right? That's Stephen's dissent that Ash said he liked, is that he talks about Sir Thomas More and he talks about A Man for All Seasons, and he says, I know what the law is, Roper. I know what the law is, and he's saying that that's not justice. That's the law. And so your job is to enforce and to defend the law, but justice, that's someone else's job, and if we get there, that's great. And if we don't, that's great. That's okay too, because Patrick equates justice with winning. Well, well, do you agree that your job as a lawyer is, as Patrick has defined it, that justice under those circumstances is my client winning, not getting what they deserve, right?
That's not
Winning.
justice, that's just your job.
Okay, so that's just your job. Ash says, no, that's not justice yet. That's your job. My job as a lawyer, that's the oath I take for the next 30, 40 years of my professional career. My job is winning for my client, not getting them what they deserve, but winning. No?
No. I guess it's an ethical dilemma.
So what's your job? Go ahead. Yeah, it is an ethical dilemma. What's your job as a lawyer then?
Represent your client zealously, whether you win or lose.
Zealously win or lose. You know, that's sort of the boogeyman of lawyering, because we put all our sins under that. We do, right? That I'm only representing my client zealously within the bounds of the law. So that allows you to sleep at night for that pedophile that you get off, and the lying plaintiff that you represent sticking his hand into the defendant's pocket, and he was never even on that bus. That's your job. So is that I'm just wondering. I'm wondering how you see your role and how you sort of align this, because if justice isn't the same as legal, and Patrick says, and I think I'm not just picking on Patrick, he just articulated it. I mean, let's be honest, right? My job as a lawyer too is winning, isn't it? They don't hire me to lose. They don't hire you to lose, do they? They hire you to win. With all their warts and holes and everything else, you're hired to win. And you know, don't give me little speeches about justice. If I want justice, I'll go talk to my minister. Go ahead.
The only issue I have is we've been doing this for many years, so why now?
Well, but you know what? I almost feel, and I hear you, but I almost feel a little bad about that, because suppose for the first 2 decades, I said, come on, can you guys leave? Come on, can you leave? It's been a while now. You really don't need to keep doing this here. You could do it somewhere else. And so, in essence, what they're saying, well, you should have gone to court sooner. Well, Jesus, I tried to talk to you for 2 decades. And I think I could see this. We tried to be respectful. We tried to cooperate. We knew that you had a role here, and we valued some of the help. But you know what? If I invited you for the weekend, 3 years in, you ought to be gone. No, and you can't say, geez, Mike, if you told me a year ago you wanted me out, I would have left earlier. Well, I'm telling you now, and shouldn't you leave? I mean, but that is the argument, is that they can't turn on a dime. Well, there's no dime going on here. The year of this decision is what, 90? 82. Okay, the first was, right, 82. So are they exiting by 85, 87? They ever get that permit? 90? When are they planning to exit this? Go ahead.
I forget what the law is called. Like it's if the airport was there first and encroachment or whatever, the neighborhood.
Coming to the nuisance. They're going to read this.
So that's the way I look at this. Isn't
but you know, just to make sure you know what the law is, I can come to the nuisance and still tell you to get out.
Well, you could try, but you have a less of an argument, correct? Or you less power?
Not really. The argument, as a general matter, and we're going to read the cases later on, is that you still have a right. You might be limited to a fixed dollar value in damages, but that's that whole Del Webb case where they came to the nuisance and the court still said, well, just, we have urban growth. And, the fact is we're in an area here where we all came to the nuisance. This whole entire area used to be full of farms. Those of you that had me for Cipro, I've given you that story. I live near a farm now. I grew up in Dorchester. We didn't have any farms in Dorchester. The first time I pulled my car into the garage in the fall, sitting in my chair in that living room, and I'm smelling shit. And I'm saying, what the hell is this? The whole house smells like crap. Well, the farmer would take the honey wagon from the top of the hill, fill it with the cow poop, bring it down over the street, put it on his field, and when Mike drove his car on that street, he filled his tires up with cow poop, and now it was all sitting in his garage and smelling. And I could see where someone else would say, well, that's a nuisance. I mean, to have your house smell like that. But the fact is that farm was there since about 1600, and I'm really the Johnny-come-lately to this area. So the rule generally is, yeah, you actually still can come. Now, your damages may be limited, but we do look at the social utility versus the changing nature of the area. And actually, on the back end here, we've had a farm there that's had a problem, and you guys did the Doonian farms early on in your law school career. But those are classes for another time. I really want to know about justice and law. So you're just lawyers. You're just hired guns, I guess, at the end of the day. Right? Assassins. You're just assassins. Whoever pays you the money, that's what they get, and that's what your job is. Patrick says winning is justice, which...
So, change.
Change what?
Change law. It's justice for me.
But how do you balance the representation of what your client wants? Right? They don't... Because really, let's be honest. They say, oh, I just want justice. No, they don't. They want to win, right? Patrick's right. They want to win. They either want to pay nothing, or they want everything the other person has in a civil case. That's maybe not everything. They don't want justice. They want to win. They can say justice, but they want to win. And if you lose them all, Patrick's not going to have many clients. Right? So...
I think it's a fine line between the two then.
Is it? Patrick says there's no fine line at all.
Oh, it is. It is.
What's the fine line between winning and justice? So you decide what's just, or you just simply, no, I'm an advocate. I effectively advocate for my client. Period. That's my job. My job is, it's the judge or the jury or someone else's job to determine, or God's, to determine justice. I'm just a lawyer. That's what he says in that dissent, right? He calls the majority sophists, right? You guys are all using logic and funky ways to achieve your results. If you didn't want to say that, because you just should have said, right? BS. This isn't justice. This may be lawful, but it's not just. And frankly, you as lawyers, you don't care about justice. That's what that paragraph says. No, you do care about justice.
I like to try to use a sports analogy here. It's difficult, but you've got to play within the rules of the game, like your more ethical rules, right? And you've got power on the other side, the prosecutor, the state, or whatever. You're trying to balance that power. Obviously, that's part of the way the sport is played, if you will, on this playing field. But then there's that piece that's called sportsmanship. You know, that's where that fuzzy gray stuff is in the middle. You play within the rules, the referee, the judge, whatever. You're playing within your rules of the game or whatever. And then there's sportsmanship, and that's the piece where I say, do you enjoy what you do for a living? Do you go home at night and sleep well? Do you want to do that every day for your life when you get up in the morning? You know, it's like, so how do you advise as a counsel to your client? You certainly can never let your client lie on the stand, of course. So do you say, I'm not putting him on the stand because I know he's guilty, right? And then you say, oh.
But do you know?
What if you did?
No. How do you know?
What if you're a professional?
No. I mean this as a serious question, right? Unless you were there, you don't know, right? This helps us sleep too, right? No, really, right? Zealous. I don't know he's lying. I'm pretty damn sure he's lying, but I don't know. No, right? But I don't know. And he says, I want to testify. This is what happened. I'm saying, I don't know, and I don't know, right? Let's be honest. I don't know. Do I think it's 99.9% likely that this is just poppycock? Yep. But you don't know.
Because there's scenarios where you've had a client that's confessed and he's actually innocent.
That's right. So we don't know. So they get to testify? I mean, because you don't, right? You don't know. Do you? You don't know unless you were there. And if you were there, you shouldn't be the lawyer.
But you can still talk to him before the trial, as far as trial strategy, and say, you know, you could say, just don't lie on the stand.
Okay, I got it.
I can't let you. You can say that.
Listen, I always tell the truth. No, I do. First thing I tell them when we talk about depositions, tell the truth. Uh-huh.
That's not going to stop them from lying. That's just going to, if they're lying, that's going to cause them to continue that same lie because, you know, one lie leads to another.
So tell me how justice factors into your role as a lawyer.
And I guess I would say, based on what because I didn't think about it until you started trying to pull it out of me. And I guess I would say I would zealously advocate for my client. You know, not unjustly, obviously. You know,
right. Fairly, reasonably,
but
aggressively.
Yes, but I think the judge is more responsible for the justice, because he's gonna listen to both sides, and then he has to fairly decide which one. And I think he has a heavier burden on him.
So the hand's in the role of the judge or the jury for justice. That's not your job. That's, I know it sounds bad. I know you look at me like, that sounds terrible when you say it that way, Professor. When you say it, make it sound dirty. But is that true? Your job isn't justice. Your job is advocacy and enforcing, or not enforcing, but pushing what you say the law is, even if it's not.
See, you added to that. You added.
Okay, wait a minute. You've been in law school a year, at least a year, all of you, some longer. You found the law in these 3 or 4, all the semesters you've been here, to be black and white?
No, never.
So, I can tell you what the law is, but I can find another case to tell you something else. No, right, let's be honest. Which case you want me to read, to use? Who's paying me? Right, yeah, whichever favors your side, right? That's the way it is. And so, to the extent that you could be slicker and more polished in your presentation and more credible, even if you don't believe it, right? I've made arguments I don't believe, right? You will too, because I could be wrong too. I know what I have to advocate for. Sounds like crap when I hear it myself say it, but if someone's going to accept it, there is a good faith argument that this could be right. Doesn't seem right to me, but no, really right. That's what we advocated.
And those are the set of skills that you've acquired.
And that's what you're supposed to do. So justice isn't your job as the lawyer. Derek, that's right. You had your hand up.
I was thinking along the same lines as you. I mean, justice. I mean, at the end of the day, it's part of it, but it really isn't up to the lawyer. It's up to the jury, the judge. Your job there is just to defend the law, defend your client to the most of your ability. And I mean, if you have the unfortunate circumstance of defending that pedophile that you speak of, I mean, you're there just to be sure that the other side is doing their job, to properly prosecute them by the rules, because everybody's afforded those rights. So, I mean, even if you are, a pedophile, you still, you're a person in the United States, you're afforded the rights. So your job is just to be sure that the other side is doing their job to prosecute them, properly convict them.
So you know what the law is, Roper. The law, right? Not.
He said it's
not
much better.
No, but it's so that is the deal. Justice, Sandy. This is troubling, isn't it, Sand?
Yes, it is.
Cases like Kinzer, where everybody in America thought this woman killed this child.
Oh, that woman did kill that child.
They were overzealous in trying to, we're going to send her to the death penalty, because at one point the case seems to be so televised and so taken over by
So that's a good example of justice or law? I'm a little confused, Ms.
That's
Kelly.
just a good example of overzealous prosecution,
Yes.
where you know you can't meet every single element and prove beyond a reasonable doubt, then we're going to have an issue.
If you're going around, just to be clear, my thoughts on that, Cal, is if you're going around with the stench of death in your trunk, you're probably in a little bit of trouble.
Right. But they still didn't produce enough evidence to be able to prove that she was, and I'm a defensive attorney, and you know that.
So your job is to defend them all, or if you're defending. So it's not justice for you, it's someone else's. That's someone else's role, as you see your job as a lawyer, right? My job is simply to advocate. Justice depends on someone else doing their job. And if the judge is a bum, or my adversary's a bum, even better, because I'm more likely to win the unwinnable cases, and that's fine with you.
I think that's what happened, though. I'm not saying that it's fine with me.
Oh my.
No, what I'm saying is, they wanted to go for the death penalty for this woman, and they couldn't produce all the evidence that they needed in order for her to get convicted on that. Had they not gone so far,
I mean, what's the big deal about using a little chloroform as your babysitter instead of hiring someone to properly supervise your child?
I'm not saying one way or the other. I'm just saying that it was poor attorney, it was poor lawyering on both sides. I just think it was just a downright awful thing of this law.
Florida.
Yes, they are. I don't disagree with that. Go ahead, Gary.
That's the key point. If you're seeing an incompetent judge or an incompetent jury, who knows, but if like an OJ.
Well, it's a jury. The juries can be incompetent too. But so what?
So if you're a really good lawyer, you got a horrible judge that's useless, like an O.J. Simpson or Casey Anthony. And Casey Anthony, by the way, they just determined that one of the reasons what happened is the police officers, detectives, didn't know how to spell a word properly, so when they did an e-discovery on her hard drive, in Casey Anthony's hard drive, she was out there searching for stuff the night before, and they couldn't spell, I forget what the word was.
I think it was chloroform,
They didn't spell the word right, and it was there on her hard drive, so it's incompetent detectives in that case, you know?
Yeah, I think there's more to that case because they tried to put the focus on her dad, saying that he molested her. So the jury became sympathetic to her. So
You gotta make
the
you gotta
attorney was
humanize.
actually, he wasn't that bad. I mean, I'm not on his
The lawyer, the defense lawyer?
Defense lawyer.
I thought he did a pretty good job. He got not guilty on.
Yeah, because the prosecutors were
He
terrible.
tried to get the jury.
No, but is that right? No, okay.
He made her look like she had a bad
You have to
childhood.
humanize it though.
Yeah.
I mean, that's the nature of the beast. You have to make because everybody's pointing the finger at the defendant.
And
at
now
the end of the day,
defense
they're
lawyer-
still a human and they
Right.
have rights.
I guess he's Spanish speaking, so now he's a big deal in Florida now
Well-
because he won a big case. So
Well,
people don't look at how bad she was.
Well, let me ask you about that, right? I mean, that is, and I sort of slipped when I said it on that case, is that, you know, he did a good job, didn't he? Because he won what I think is an unwinnable case. He won a case he shouldn't have won, in my opinion. That's my opinion based on my review of the evidence. So he is a good lawyer, right?
Yeah.
No, right? You winning the ones you shouldn't win says that you are better than some others, right? So that's the deal, though. So that's the deal, that you're even a better lawyer if you make sure justice isn't met.
No, that just made me realize that their prosecutors were terrible.
What?
I said that just made me realize that their prosecutors were terrible because he did. I looked.
No, he did, but he painted. You said he made her sympathetic.
Yeah.
Oh, well, how is that sympathetic?
That's what you taught me.
I know I taught you that, but I want to know. So that is your role in this process. Just as Stephen says that you're not about justice. You're about winning. Winning is justice as far as you see. Derek's point, Sunshine's point. That's someone else's job. That's judge, jury, God, who knows? Not mine. My job is winning within the bounds of the law and advocating effectively. And then occasionally, hey, maybe we'll have justice. Spin the wheel, see what happens. But I don't have to worry about that. It doesn't even factor into my thinking. True? Go ahead.
I think justice is purely subjective. I mean, it all depends on what angle you're looking at it from. You know,
So just to take the extreme example I've been using, so the pedophile who did it, not going to jail, that's justice, if that's what happens.
To him it is.
well, I mean, I know defense attorneys that would be, you know, jumping up and down thinking that was great because, you know what, the other side didn't follow the rules, whatever, and,
So is it all subjective? People shouldn't get what they deserve, they should get whatever they get.
no, I don't mean it that way. I mean, as terms of how people view justice, it's subjective.
Go ahead.
I think our justice is the Constitution, basically. And as long as we're upholding that, like Kelly said, everybody has these rights. Our forefathers decided these rights before we even got here. So as long as we're trying to uphold those rights, then it would depend, if you're a good lawyer, depending on what you think a good lawyer is. And if you're being a good lawyer because you're upholding those rights, then even if the pedophile does get off, then indeed you did do a good job.
So there is no right or wrong.
But I definitely think you do reap what you sow, so I don't know.
So there is no right or wrong. It's only a question of whether the Constitution is followed or not. Your own personal sense of right or wrong doesn't factor into your role as a lawyer.
Well, the founding fathers were not perfect either. That's why we have amendments, and so, you can't just say we just have to uphold whatever the Constitution says.
So it's the Constitution. Right or wrong doesn't factor into your job as a lawyer either. Go ahead. What's your name again? Mustafa.
I don't think you should, as an attorney, you shouldn't take a case on and judge it right off the bat. I mean, you have the right to refuse a case if you don't want to. Okay,
but Mustafa, you didn't judge it right off the bat, but you're 3/4 of the way in. You say, "Oh, geez, I got the bad guy." And I got the. I've been there. I said to my wife one time, I said, "I think I've got the wrong side on this." It was a messy custody thing, and I said, "I think I got the wrong side, Jeannie." I said, I really don't think I should win.
Well, then you're in a dilemma, because if you decide to turn your back on your client, you're probably going to go down for malpractice.
Well, I can't turn my back. I can't take a dive. That wouldn't be, that clearly can't be ethical or appropriate. Huh?
You have to continue.
So I have to continue to represent the side that I really think I've got the wrong side, and if I'm successful, these children's lives are potentially forever affected because I'm a great advocate. That's...
No, you can turn down your client.
No, but I didn't. I've got them now. I'm way in. I'm telling. This is for real. I'm not. This is not. I'm way in. And I say to my wife, who did a lot more of these, I said, Jeannie, I think I really got the wrong side here. I think what I'm at. It was breaking up brothers and sisters. They didn't know each other, but I have 5 brothers. I have a family of 5, and we're very close. And I'm thinking halfway in that I value being with them more than virtually anything. And now what I'm advocating for is that they shouldn't spend the rest of their lives with their older brother. And I really think that's wrong. I think personally, I'm telling you, personally, I think that's wrong. I think that's one of the worst things I saw in many of her cases, is that they would take 3 kids who the only stability they knew was each other and disperse them. And that just seems so wrong to me. So
I'm sorry.
No.
That speaks to the fact that, I mean, in family law, there is no justice in that courthouse.
Now I would tell you that I expect that she would disagree with that, since she spends her entire career there now. I'll tell you what she told me, just so, because I think it's in line with what you said. She said, that's not your job, Michael. She said, that's not your job. She said, you don't get to decide whose custody they go into. She said, that's not your job here. Your job is to advocate on behalf of the clients. And my clients were good people, really good people, just so we're clear. It's just, huh?
On behalf of the client.
Right.
So whatever the
And
client wants, we have to.
Which in this case meant splitting the 3 siblings, 2 twins, and I'm a twin. Okay, so this is why, especially, no, I'm serious. This was personal now.
But that's what I'm saying. So if we're gonna work as an attorney for a client, we have to advocate for what they want, whether we like it or not.
So it's not about justice, and it's not about right or wrong. That's all. I need you to start to think about, okay, so where do your personal feelings come in here? And
They come after your client's interests, you know.
Well, I would sit down in that case. I would sit down with my client, because if I'm going to advise my client, I'm going to advise.
Oh, they didn't want me to hear, you should give up the twins that you've had for 3 or 4 years now and give them to the other family. They did not want to hear that. I don't blame them. I wouldn't. I would say, go to hell. I mean, seriously, give up children that you believe are yours. Of course they believe they're yours. I've raised them. They're 4 years old. They've been with the only parents they know are ours. There's no, frankly, in that case, there was not going to be a good result no matter what was done. It was going to be bad.
So what you do is you professionally advocate, but in real life, you're not going to go the extra mile.
Oh, so they get less than my full abilities? I'm just asking. So less than my full abilities? I like Sandy. She's getting 110%. Ash, just the top level. That's it. No extra. I'm not staying up till 2 a.m. for Ash.
Exactly. In real life.
No, really? Exactly?
Oh,
don't you have to be careful with that?
In real life, you're going to give professional advocacy to that pedophile or that scenario that you painted that was impossible, and you're going to do your job. That's it. You're not going to stay up to 3 o'clock in the morning fighting your butt off for the case.
I don't think that's.
Your job requires you to stay up till 3 in the morning. You're going to stay up till 2?
I'll tell you exactly what I'm going to do, but not here in public.
Is the effort, as long as they all get 100, that's okay, but some of them are going to get 150. Some of them are going to get 200% effort. Well, let me be realistic just for a minute. You're not going to fight a little harder when that's your niece and nephew or a close family member than some others? I mean, or is that not fair either? Listen, you can decide. You need to start to think about now how these things fit, your own sense of values and the like, because I think it's important that you figure out how this fits to make sure that you're comfortable in your own skin as you practice law. The other 2 cases I think are important as well, and so I want you to look at them, and we've got Clinton versus Nagy, I thought, was particularly interesting. We could spend some time on, and the case is really dated at this point, whether little girls should be playing football. Obviously, they've been playing for a while, and they play hockey, and boys play field hockey and everything else, so that these long-ago mixed teams. But I think what's interesting about that case is the timing of them seeking the order. the disposition of that order was going to fully resolve the case, because she would never be eligible for the Pop Warner football again. So what they did is they prepared their case, they waited till really pretty much the season was just about there, and then they sought it. And the fact is, it was almost a bulletproof order by the time they got it, because this situation wasn't going to repeat itself for her. She was going to be moving on. And so what they did is they used that injunctive relief process itself strategically and tactically to gain everything they wanted, so that the client got precisely what she wanted, and for all intents and purposes, nothing else was going to come of it. I think it's a very clever and appropriate use of the process to gain what you want and to have it used so that the defendant is at a disadvantage at that point. But I don't think there's anything wrong with that. I think you guys have to know the rules to the extent that you can use them to advantage your client. I'm certainly more comfortable on that than how all the rest of our earlier part of our discussion fits into how you personally, your own personal decisions about right and wrong and justice matter with respect to representation of clients. Mustafa.
I was just going to say, in that case, the judge didn't actually order the defendants to make her play. It's kind of like, I compared it to the first case where they gave the Navy that unlimited time to get that.
Right.
I'm sorry.
Yep.
But here, I mean, 2 games left. He left the discretion up to the coach to put her in or not. So I don't know how much they actually gained out of that. And then suit up and you're on the bench. So.
Well, but again, with personal services and the like, and these are we're going to see these in other contexts. The court can say you can't dismiss her from the team, but they're never going to be able to say, virtually in any context where personal services are involved, paint the picture. You get to be chief executive officer of the company. Hire that professor. Well, sometimes they will say that if it's been discriminatory and the like. But more often than not, they're likely to say, you're going to pay damages for not hiring the professor. It's hard to get specific performance of these personal services contracts. So they can say, that's right, the coach at the end of the day can still sit her on the bench. What you can't say is that because of her gender, she doesn't get to play. So you're right. At the end of the day, she still may not get exactly what she wants, but she's never going to get an order that says, play her at left guard for 50% of the plays. No court is really going to be able to undertake that. And then the other case was the busing case that I think was just important from, as you saw, the timing and the process as well. So we've got we go to section 2 for Thursday's class. We'll talk to you all next time. Thank you.